Hello, everyone, and welcome to a special video for the Legal Studies guy. Today, looking in a little more detail at dot point 4.1.4 from the study design, which is in relation to constitutional checks on lawmaking. Quick quote to start, a little bit deep today. He who fears he will suffer already suffers because he fears. And just wanting to link this into, everything that's happening in the world at the moment, particularly focusing on the impact on your Year 12 studies, with everything being a little bit condensed, I suppose. Well, obviously, timeframes actually lengthened out, but in terms of the time that you have at school, and just that idea of trying as hard as you can not to, I suppose, fear what might be coming, because that will then, I suppose, stop you or impact you from being able to do the best you can right now, and will make you suffer a bit more right now. So trying to put some things in place to work with that. So as I said, today really focusing on this constitutional checks on lawmaking. So from the study design here, 4.1.4, the means by which the Constitution acts as a check on Parliament, and then those 5 specific things. So bicameral structure, separation of powers, express rights, High Court, and referendum double majority provision. So really going to focus on how does the Australian Constitution act as a check on the lawmaking of Parliament, with a real emphasis on some past exam questions to give you a look at exactly what the examiners have said they're looking for. And we're not going to, I suppose, get too bogged down on the content, because there's another video that you can watch to help you with that. Just a reminder that the study design has changed this year due to the coronavirus impact. And this is the one area of study that has been hit the most. So you'll see originally this area of study had 8 key knowledge points up here, and it's actually been cut back to 4. So these last 4 key knowledge points have been removed. But if your teacher hasn't showed you this already, just highlighting that each one of these is basically a case study, more or less. So the significance of a High Court case, sections 7 and 24, significance of a referendum, significance of a High Court case impacting division of powers, and then international treaties and declarations and treaties, in the external affairs power, which most teachers use a case study to demonstrate anyway. So what they've essentially gutted out of this section of the study design is all the case study options, but left you with the more or less essential content that you still need to understand and work with. So, for instance, they've taken out a High Court case interpreting sections 7 and 24 and a High Court case which has an impact on division of powers, but we still need to understand and know the role of the High Court in interpreting the Australian Constitution. They've taken out a referendum where Australian people have protected or changed the Constitution, but we still need to know the requirement for a double majority in a referendum. So they've, I suppose, just taken out that next layer, but there's still, we still need to understand the base content around the High Court, what the Australian Constitution establishes in terms of their powers, the requirement for a double majority in a referendum, etc. And look, that just means in terms of key skills as well, they've taken out the significance of a High Court case, as I said, and the impact of international declarations, but left everything else. And we're going to talk about this a little bit as we go through, but we have in the past focused on this dot point a lot. So evaluate the ways in which the Constitution acts as a check on Parliament in lawmaking. So looking at these 5, and then more or less strengths and weaknesses to be able to say, are they a good check or not? But I'm also going to talk a little bit about this dot point, analyse the ability of the Australian people to protect or change the Australian Constitution, because at first glance, and with the language around the referendum here, a lot of people have just thought that, this skill is only in relation to referendums. But I'm going to show you with with one past exam question in particular, how the role of the Australian people links also to the High Court, the bicameral structure as well. And you'll see, I suppose, the different breadth of questions that you could be asked on this area, even though we don't have cases to look at. So look, I've asked this in the other video, but considering I think it's important to start from the point of why do we need a check on lawmaking? And I think pretty clear is the idea that if we don't have some form of structural embedded checks on what Parliament can do, that's how you go down the path of getting to a dictatorship and whatnot. So you don't want a Parliament to have the ability to just say, well, we're going to change the law to not have elections anymore and we're going to be in power for forever. Like, you want to make sure that structural protection's there so that every few years the people get a say. Otherwise, again, you're opening yourself up to potential corruption. You're opening yourself up to dictatorships and that sort of thing, where all of a sudden people's individual rights are threatened. So that's really why you need to make sure that there are checks on lawmaking that are embedded into your rulebook, your constitution. So the first check that is listed is the bicameral structure of Parliament. So again, I'm not going to bog down in this too much because there's another video that you can look at. So super quickly, we know bicameral means two houses, an upper and a lower. In the Australian Parliament, it's the House of Reps and the Senate. And I'll talk about Section 7 and 24 in a moment because we used to have to know a High Court case relating to them, but they're important to actually read those sections of the Constitution. So how does it check Parliament? Look, it just means that first and foremost, that if you want to pass a law in Australia, you have to get it through both houses. And we've actually got a past exam question that shows you that you really need to know that point, that it has to go through both houses, or else you missed a pretty key part of the question. We then can talk a little bit around the bicameral structure and how it means all legislation is going to have to be considered, debated, agreed upon by multiple viewpoints, because one party rarely has a majority in both houses, like extremely rarely. So what this means is Parliament is checked as well, because they can't just make laws that suit a small portion of the population or suit them. Or the government can't. Every law passed has to be well considered. And we're going to look at an example in a minute that shows you both how well considered a law can be, but also how tricky it can be to pass a law full stop. Section 7 and 24, and I'll just come back to that in a second. Section 7 of the Constitution, it's really important to know, is about how the Senate is elected. And you'll see this point here that I want to focus on. The Senate shall be composed of senators for each state directly chosen by the people, okay, voting as one electorate. If we then look at Section 24 for the House of Reps, the House of Reps shall be composed of members directly chosen by the people and shall be twice the number of senators. What that means is, as well, when we're talking bicameral structure, we can also look at this idea that due to Section 7 and 24, members must be elected. They must be directly chosen. So the Australian people have a role here as well, in the sense of, if Parliament makes laws that aren't in our best interests, we have the power through the bicameral structure, through Section 7 and 24, to vote for someone else. So this is a check on Parliament's lawmaking, because they have to pass laws that are considered. They have to pass laws that cover multiple viewpoints, or else they will be voted out at the next election. So in terms of applying this key content, we've got this example here. So in 2019, November last year, the Government of Australia wanted to pass a law called the Ensuring Integrity Bill. And the whole idea of this law was it would basically make it easier for regulators to take control of unions if they didn't meet certain requirements. So some really, really quick background. As a general rule, the Labor Party was formed from the union movement, and really unions are all about protecting workers and workers' rights. There is, I suppose, the Liberal Party is more supportive of business interests, and as a result don't always have a great relationship with unions, because unions don't necessarily or unions, want things that maybe businesses don't, such as better pay and conditions. And as a result, often when the Liberal Party's in power, they look to put things in place that make it harder for unions to operate. So basically a law that would make it easier to take control of unions if they didn't do the right thing. Easily passed the House of Representatives because the government have a majority. So that's important when understanding the bicameral structure, is that the government has a majority in the House of Reps, usually, and as a result can pass any law they want through there. What then has to happen is they have to get support from other parties in the upper house. The Senate has 76 seats. The government only hold 36. So to actually pass something through the Senate, you need half plus one. So you need to get to the magic number of 39. So if Labor have 26 seats, and we already know that Labor like the unions, the Greens have 9 seats. Dare I say it, the Greens generally don't get on well with the Liberal Party, so we'll cross them off. We all of a sudden see that the Liberal Party, to pass any law, more or less need to either get Labor on board, or they need to convince 3 of these remaining senators, so 2 senators for One Nation, 2 for the Senate Alliance, and 1 for the Lambie Network, to vote with them. And that's, I suppose, their challenge, and that's where we have debate, and in a way laws need to reflect a wide range of views. So in this instance, the government got these 2 votes, so they got to 38, so they needed 1 more. And Jackie Lambie said no. So they were relying on One Nation. So what ended up happening was this proposed law spent a week in the Senate. And in that time, they discussed lots of different amendments and little changes to it. It would then get passed back to the House of Representatives to pass again in the same format. But they made lots of changes. Particularly, they made a bunch of changes that One Nation wanted. And the whole idea was that we'll make these changes for you, and then One Nation will approve the bill, and we're going to get this bill through Parliament. And as I said, this went on for a week. And then when they had the final vote on the bill, One Nation did what we know as crossing the floor, which means if Parliament is constructed like this, and you've got the government and you've got the opposition, actually the other way around. When we have a vote, if you are voting yes, more or less, with what the government has put forward, you would come and stand over here. And if you're voting no, you'd go and stand over on the other side of the chamber. They literally divide the chamber. It's called a division. And One Nation had basically been putting forward these amendments in consultation, had been always coming over here to vote. And then literally on the last vote, when they were deciding whether it passed or not, One Nation got up and they went over this side of the floor instead. So they crossed the floor. And this picture is actually of Liberal Senator Anne Rushton at the moment when One Nation voted against the government. So she's been organising all week and basically yes, we've done this, we've got this law passed. And you can see the look on her face when, in a way, she gets blindsided. What this is showing us, again, is how the Senate checks, or the bicameral structure checks, the lawmaking of Parliament, because you have to debate. You have to make amendments to bills to make sure they meet a wide view of people, or if you don't, they will not pass. And where this happened in a question was the 2018 exam in Section B, Question 3. And the question was, a case study, Australian Greens Senator Jordan Steele-John introduced a bill into the Senate about lowering the voting age. And it said, here is the Senate data. These are the people that have seats in the Senate. And the question was, discuss the ability of the Commonwealth Parliament to change the law to allow 16 and 17-year-olds to vote in elections. 6 marks. And you can see here the average was only 1.7. But this question really, and it says it here, it synthesises the stimulus material and knowledge of the Houses of Parliament, factors that affect lawmaking from Area 4.2, but also the bicameral structure itself and how that checks. And particularly here, it says the government did not hold a majority in the Senate were critical facts relevant to the discussion. And I like this point in there, sample answer. The bill would need to be passed in both the House of Representatives and the Senate in order to become legislation, and the Greens do not have a majority in either house. So that's a little bit more factors that affect lawmaking on who has a majority in either house. But really, the point is that you just simply needed to know that the bill needed to be passed in both the House of Reps and the Senate, and in a way how that acts as a check on lawmaking. So next up, we have the separation of powers. Look, it's a really a tricky concept, I suppose. But in terms of where it's shown up on past exam questions, it's been a little bit limited. So we won't spend too much time on this, but I will show you specifically how I suppose you're expected to understand how this works. So the separation of powers, not to be confused with the division of powers, is the splitting of legislative, executive and judicial power to separate bodies. So taking our legal system and splitting it up into 3 parts. Those parts being legislative, so the power to make laws, executive, administer laws, so basically manage the country, run the country, and then settle disputes arising under the law, so the judicial power. And as we know, look, Parliament makes laws. It's then the government, so the Prime Minister, his senior ministers and cabinet that then sort of run the country and make decisions on day-to-day operation. And then it's the courts, the High Court and other federal courts who settle disputes. And look, the whole idea of this is it prevents power from being concentrated in one set of people or one group of people. Which means that, you know, if the executive branch is doing the wrong thing, that the courts can step in and check them. If Parliament makes a law that contravenes the Constitution, the High Court can actually overrule it, which we'll cover shortly with the role of the High Court. But more generally as well, it's a structural protection. So you'll see that the Constitution is actually broken up into chapters based on this is what the legislature does, this is what the executive does, this is what the judiciary does. So that's structurally protected, which means Parliament can't take part of the judiciary's role and give it to itself, or it can't take what the judiciary does and give it to the ministers. It's actually structurally put into our Constitution and separated in our Constitution, which means it can't be removed or changed without a referendum. A really, really quick example is a case that just went through the courts last week, actually. And it was about a visa application. So you need a visa to enter an overseas country. This person wanted to come into Australia. I believe that they might have been an asylum seeker, and they had applied for a visa. The types of visas that you can get, the different ways that you can enter this country are all set out and governed by a piece of law. And that law is called the Migration Act, which was passed by Parliament originally in 1958 and has obviously been amended quite a bit since. So Parliament, the group of people in Parliament in 1958 passed this law. And that's everyone in Parliament, government, opposition, crossbenchers, etc. In this law, it gives certain powers to the relevant minister, who is the Minister for Home Affairs these days, including the ability to decide whether a person gets a visa or not. So particularly in this case, it was about whether the individual passed what's known as the character test, which is a set of conditions around not having convictions in other countries, not more or less not being part of, say, a terrorist group and that sort of thing. And if there's any evidence that you are, or if the minister simply thinks you could be, they are able to deny you a visa. So in a way, you can see that separation there. The Parliament made this law, and then the executive gets to actually administer it. Finally, you've got then judicial power. And if an individual believes that the law hasn't been applied properly or appropriately, or perhaps even not used at all, they can ask the courts, the independent courts, to review it. So what happened in this matter was this person applied for a visa, and more or less the minister didn't make a decision. And due to a range of things, effectively the person had applied in 2016, and we got to the point a few weeks ago where this person still didn't know whether they were able to get a visa or not. So that's 4 years, and I think they've been in detention for that entire time, so locked up. And basically they went to the court and said, as an independent court, we need you to step in and make sure that the minister does their job. And the court actually stepped in and said that the Minister, Peter Dutton, had to make a decision by midday on the 3rd of July. And if he didn't, he would be held in contempt of court, which means he could even potentially be imprisoned. So it just shows you that no matter what, I suppose, what power the executive has, they still aren't completely unchecked. They aren't above the law. They can still end up in court with the court saying, this is your job, you need to do it, and if you don't, there are punishments, there are sanctions. So it shows you again the idea of checks and balances and making sure that power isn't concentrated in one person too much. There's not a past exam question really from the current set of exams that really address this. So I just went back to 2017 and found this question. Following criticisms of judicial decisions, a law has been passed that will allow members of Parliament to hear and determine court disputes. Would this law be valid? Justify your answer. And more or less, like if you take judicial power, which is hearing court disputes, and you legislate that away from the courts and to members of Parliament, you're breaking the separation of powers, which you can't do. And as it says here, the question assessed students' knowledge of the separation of powers, and more particularly, the constitutional requirement that the judiciary be independent and separate from the legislature. So potentially you're looking for a question that might come up like this, where you need to know that no, that separation of powers can't be changed by Parliament. It's structurally listed in the Constitution. And you'll see here, therefore, the Constitution's separation of power ensures that only the courts and not members of Parliament are able to hear and determine court disputes, making the law they made invalid and unconstitutional. And that's a really clear line at the end there, or word at the end there, unconstitutional. So that's how you're expected to, I suppose, apply the separation of powers on an exam. Our third constitutional check on lawmaking is the express protection of rights. Again, super quickly, these are our 5 rights that are listed in the Constitution. They can't be changed. They can only be removed or changed through a referendum. They are freedom of religion limited, discrimination based on state of residence not allowed, free interstate trade, just terms for acquisition of property, and trial by jury for Commonwealth indictable offences. More or less, Parliament can't make laws that contravene or restrict these. It's that straightforward, and any legislation that does breach it can be challenged in the High Court, provided that it's challenged by someone with standing. We'll talk a little bit about how this then fits in with that extra key skill of analysing the ability of the Australian people to check Parliament. A quick example though, Clive Palmer. Clive is actually is going through the process of initiating a High Court challenge at the moment in a case called Palmer versus Western Australia, and it's against the fact that Western Australia has closed their borders due to coronavirus, so they're not letting people from other states in. Clive Palmer lives in Queensland, and he wants to travel to Queensland because he has business interests there, but also because he wants to meet potential new members of his political party, the United Australia Party. And more or less, he believes that Western Australia has breached Section 92 of the Constitution. So that is, as we saw here, free interstate trade and commerce. And it's actually like free, more or less allows for free thoroughfare between the states. And he said, well, closing the borders actually breaches the Constitution. It is listed to be heard later this month. They're going to establish facts in the federal court, and then once the facts are established, so ensuring he has standing, I suppose, and who's closed what and who's said what, all of this will be put together and given to the High Court, and then the High Court will actually hear the constitutional dispute. So the High Court will consider all of the facts in relation to Section 92 and make a decision about whether the WA border closure is unconstitutional or not. You'll see here that Palmer was also considering initiating a dispute against Queensland, but was warned he may not have standing. And that's because he's actually lives in Queensland. So as someone said, you might not have standing, Clive, because you're not actually restricted from entering Queensland because you're currently in Queensland. And in a way, this example shows the power of the High Court, because the High Court and the role of the High Court, because the High Court can declare WA's decision unconstitutional potentially, but also express rights that you can't make a decision that breaches these. And look, the key question with this is the High Court will have to consider what was the primary reason for closing the borders. And if the primary reason for closing the borders was to restrict trade and commerce, then it would be unconstitutional. But past decisions have shown that if the primary purpose, and it can be established that the primary purpose is to protect people's health, because there's a disease outbreak, and in a way, the potential restrictions on trade and commerce and thoroughfare between the states was a secondary impact, but a proportional one considering the primary reason why, then it's likely that the border closures will stand and be allowed. So that's just more or less, a lot of constitutional experts think that the dispute won't be successful. So we look here at question 6 from the 2019 exam, so last year. And it said, Section 116 of the Australian Constitution states the Commonwealth shall not make law for establishing any religion, imposing religious observance, prohibiting the free exercise of religion, and so on. And the question is, discuss the extent to which the Australian people can prevent the Commonwealth Parliament from making any laws on religion. So it's again a question asking you to consider both sides, discuss the extent, and it's about the level to which the Australian people act as a check on Parliament in relation to express rights, Section 116. So a little bit of how much of an actual check is Section 116 and the express right itself, and a little bit of what's the role of the people here, which is that extra skill dot point, analyse the ability of the Australian people to protect or change the Constitution. And look, this question was actually done quite well, considering its difficulty and considering the history of 10 markers. And if we see here, some people limited their answer to 2 main points: the referendum process acting as a way to prevent the Commonwealth Parliament from expanding its powers, which we'll get to, and the ability of people to take a matter to the High Court if the Commonwealth Parliament makes laws on religion beyond its powers to do so. And that's where I suppose this question gives us a good insight into what the examiners are expecting us to know about express rights. And you'll see here, it's expecting us to not only know what they are and how they operate, but also in a way the scope of them or the extent of them. And you can see here the first point is that Section 116 is limiting. It does not say the Commonwealth cannot make laws on religion, just that it can't make laws on specific aspects of religion. So that's a really important point for us to know, is that, the examiners can ask us to really drill down into each of these express rights. So we don't just need to know what express rights are overall. We need to know the individual ones, and we need to know a little bit about how much they act as a check on Parliament individually. Because it doesn't act as a complete restriction, and in fact there are many laws about religion. So that's an important point. I'm not going to then go into more detail then about how the High Court comes into it and the referendum process, because that's what I'm going to include in the next section. But again, just a bit of an insight into we need to be able to drill down into these express rights quite a bit. So our fourth constitutional check on lawmaking is the role of the High Court. This really extends on from the express rights, because obviously one of the big factors of the express rights is the ability of the High Court to then declare legislation that breaches them invalid. And then also really then dives into that whole idea of not just being a constitutional check, but also being part of the way the Australian people can protect the Constitution through, or change the interpretation of, through their ability to bring High Court cases. So look, as we know, High Court is independent of Parliament and government under the separation of powers, means they're a impartial, unbiased voice that can rule on disputes involving those bodies. And basically the High Court has the power to rule on any matter involving the Constitution. So they would hear Palmer versus Western Australia, for example. Basically, if it's got to do with how the Constitution's applied, High Court will deal with that. And look, how does it act as a check on Parliament? Again, we've spoken about this. They have the ability to literally declare legislation invalid. So prior to the case is brought, just say, nah, that law struck out, it doesn't exist anymore, which is a pretty big power and a pretty big check on Parliament straight up, in that the High Court can just take a law that they've made and say, nah, that actually, you're not allowed to do that, that's gone. Something else that the High Court can do as well is, from reading parts of the Constitution, they can actually find new rights that are implied by the text, but aren't expressly written. So, for example, in 1992, the High Court ruled on a case called Australian Capital Television versus the Commonwealth. And more or less, really, really simply, what the Commonwealth had done was they had passed a law that restricted political advertising. So in the lead up to an election, you get all those ads, such and such did this and he said that and he said this, and at the end it's like authorised by the Liberal Party Canberra or authorised by the Labor Party Canberra. And I think everyone gets quite annoyed by those ads. So what happened was the Commonwealth basically said, there's a limit on how often these can be on TV and there's a limit on how often these can run. And Australian Capital Television took the Commonwealth to court and said that that law breaches the Constitution because of Section 7, Section 24, the need to be directly chosen by the people. What's implied there is that the people need to be politically informed, and therefore the government shouldn't be allowed to restrict political communication. And the High Court agreed, and they said the Constitution, in allowing for the people to be directly, in allowing for the Senate and the House of Reps to be directly chosen by the people, the founders of the Constitution were implying there that political communication should be free. And as a result, this or no law can be passed that breaches this. So that's, again, how the High Court can step in that they can actually not only rule on current rights, they can find new rights that then exist in perpetuity. So, an example. If we look at this section of the Constitution, Section 51 lists all the powers of the Commonwealth. The Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to, and I want to focus on Clause 5 here, postal, telegraphic, telephonic and other like services. And I want you to think for a moment, what is a like service? So what is it that post, telegraph and telephone have in common? And then what is, or what would we consider to be a like service? Effectively, back in I think it was the 1930s, there was a woman called Mrs. Brislin. And Mrs. Brislin owned 5 radios. They were all hooked up to an aerial at her house, and she had no license to own radios. And for whatever reason, I think because obviously new technology often used for secure communication, etc. But as per a law passed in 1905, you had to have a license to own a wireless radio. Mrs. Brislin, 5 radios, no license, therefore has broken the law. So she's charged, she actually gets convicted and gets given a fine. And she decides that she's going to challenge this law in the High Court because, according to her, wireless radios aren't mentioned anywhere in the Constitution. So why does the Commonwealth get to pass a law on wireless radios, restricting them, meaning you have to have a license? So she says the law is unconstitutional because the Commonwealth does not have a head of power to make this law. The Commonwealth just says, well, wireless radios are a like service. Wireless radios are really similar to the post, telegraph, telephone. They're a like service, which means we have the power to make a law on them. And I think this one's pretty clear-cut. I think it probably is. It makes sense. And the High Court found in favour of the Commonwealth. They said, hey, post, telegraph, telephone, common thread here is communication. Wireless radios, again, method of communication, all about communication. So therefore, we're saying that like services are anything to do with communication. So anything to do with communication, the Commonwealth has power over. Okay? It's a concurrent power. States still can make laws on that. But anything to do with communication, federal government can do what they want. Now, this really broadens the power of the Commonwealth. And this is one thing that the High Court can do. It can check Parliament, but it can also increase Parliament's power. And in this case, it broadens or clarifies and then broadens what like services means, anything to do with communication, and therefore the Commonwealth has broadened power. So, for example, these days we have a national broadband network. And the federal government makes laws regarding social media, the internet, etc. And that's all because back in the 1930s, the High Court said, this is what Clause 5 of the Constitution means. Therefore, anything to do with communication is the Commonwealth's. So it's important that we understand that the Commonwealth could have restricted Parliament here and checked Parliament and declared their law invalid, but they actually, through argument, went the other way, and they've actually given the Commonwealth more power. look, question 6 from 2018 covers this a little bit. It's evaluate 2 ways in which the Australian Constitution enables the Australian people to act as a check on Parliament. I just want to show you here, if I remove this little bit and we reread that question. Evaluate 2 ways in which the Australian Constitution acts as a check on Parliament in lawmaking. And that's really, really, really directly that skill we've been looking at, 4.1.5, evaluate the ability of the Constitution to check Parliament, more or less. And that's any of the 5 things that we're talking about. But where this question really tripped people up, and the average is 3.3 out of 8, was adding in this element of 4.1.6 as a skill, the ability of the Australian people to protect or change the Constitution, and evaluate 2 ways in which the Australian Constitution enables the Australian people to act as a check on Parliament. So all of a sudden it means checks on lawmaking such as the separation of powers we can't really use here because it doesn't really involve the people. We've got to make sure that any check we talk about is linked to the Australian people. So potentially you can talk about, well, not potentially, you can talk about how sections 7 and 24 mean Parliament and the bicameral structure has to be chosen by the people. Therefore, Parliament can only make laws, they're checked, they can only make laws that people agree with. But in terms of the role of the High Court, I want to focus on particularly this one, and then we'll look at the one above. The right to challenge Commonwealth laws in the High Court, either generally or because the law infringe upon the express rights in the Constitution. So what we're saying here is, and what the examiners are telling us is, one of the things we need to know about the High Court is it gives the Australian people the ability to check Parliament because you can challenge laws in the High Court. So that's a really important point. When we talk about the role of the High Court, we can talk about the people's ability to bring cases to the High Court. And as part of that, that potentially means that the High Court also finds new implied rights. Okay? So that's something to really focus on. You'll see here, the question was challenging for many students and very few achieved full marks. The key differentiating factor in this question was the link between the check on Parliament and how the check enabled the people's participation. And that's going to come up as we talk about this last one, which is the double majority provision. I'll talk about, double majority in relation to the question from last year as well. So look, double majority, last one, last check that we have to cover is the idea that to change the Constitution, you have to have a referendum. In a referendum, every voter in Australia must vote. So all 18 million eligible voters or whatever it is. And the only way a referendum can pass is if a majority of voters in Australia overall vote yes, and also a majority of voters in a majority of states. And more or less what this means is that any change to the Constitution has to have broad public approval. Okay? You have to have a majority of voters overall, but you also have to have a majority of the states on board. So the majority of people in some of the smaller states. It can't just be dominated by Victoria and New South Wales, the 2 largest states. And it really does act as a check historically because only 8 out of 44 referendums have been successful. So we've tried to change the Constitution 44 times in 120 years. And we've only successfully done that 8 times. That's less than 20% of a success rate. A very quick example of the Constitution being changed is the 1967 referendum. That's where we had Section 51, Clause 26, that used to say the Commonwealth could make laws for the people of any race other than the Aboriginal race for whom it is deemed necessary to make special laws. And we got rid of the other than the Aboriginal people part. So the Constitution now reads, the Commonwealth has the power to make laws for the people of any race for whom it is deemed necessary to make special laws. And what that means is the Commonwealth has had the legislative power, the head of power now, to basically direct funds towards Aboriginal affairs. So previously, states with large Aboriginal populations couldn't get extra funds for this because, as well as removing that little section, we removed section 127, which used to also state that Aboriginal people didn't count in the census. What this change did is when 90.77% of the Australian population agreed and voted yes, this change gave the Commonwealth more power. And it gave the Commonwealth power to make laws specifically for Indigenous people. And these days we have things like there's always someone in the federal government who is the Minister for Indigenous Affairs or Aboriginal Affairs. There's an Aboriginal Affairs portfolio. You can direct, or the government can launch specific Indigenous health, Indigenous education, closing the gap, I suppose, initiatives and direct funds directly towards it, rather than having to rely on the states to do all of this funding themselves. So this is an example of how the Australian people can, in a way, grow the lawmaking power of the Commonwealth by agreeing to constitutional change. So the people looked at this and said, yep, we've listened to the arguments. We think it's in everyone's best interest for us to vote yes, and as a result, increase the lawmaking power of the Commonwealth. But you can also look at this from the other side of the coin and say, if the majority of voters thought giving the Commonwealth more power was a bad idea, then the double majority provision enables them to say no more power for the Commonwealth, and therefore is a really effective check. And effectively what we're saying here is the Commonwealth cannot just legislate to give itself more power. The only way it can broaden its power is either through the High Court interpretation, like we looked at a second ago, or more or less by getting the people to approve a constitutional change. So, final question we'll look at. 2018, Section A, Question 6. Again, evaluate two ways in which the Australian Constitution enables the Australian people to act as a check on Parliament. And following on from the examiner's report that we looked at, or the first part of the examiner's report that we looked at with the last question, very clearly the examiner's report goes here and says, for example, some of the points that students could have drawn out in relation to the double majority requirement were as follows. So again, how can the Australian people act as a check on Parliament? The people get to choose if the Constitution is changed or not. The Parliament can't just change the Constitution. Again, the Parliament can't just give itself more power without putting it to the people. And the double majority provision is difficult to achieve. So people need to be convinced that the change is required or they'll vote no. So again, the Australian people have a lot of power here because, again, the Commonwealth, the Parliament can't get more power without their approval. However, if we consider the other side of this, to initiate a referendum, Parliament first has to agree to it and has to vote on it. So the people actually have to wait until Parliament agrees before they even get a chance. So if the Australian people really want to change to the Constitution but Parliament doesn't, then Parliament don't need to bring a referendum forward. But likewise, then we can talk a little bit about bicameral structure, and if they don't bring the referendum forward that people want, people can then just choose to vote them out. And finally, if you want to talk a little bit of history, one of the points that they say you can draw out is it can be questionable about whether referendums and the double majority provision are actually a effective check, because there just simply seems to be a deep reluctance to change the law. So only 8 out of 40, or change the Constitution, only 8 out of 44 have been successful. this really shows that people just don't want to change the Constitution. So even if a change is actually a good idea, is it going to go through? So is it an effective check on Parliament lawmaking if all we're ever going to do is vote no? The other thing to consider the double majority provision with is, and I'll skip all the way back, very quickly, this question. Discuss the extent to which the Australian people can prevent the Commonwealth Parliament from making any laws on religion. And as it says, one of the ways that you could have answered, or one of the things you could answer in this question is the referendum process acting as a way to prevent the Commonwealth Parliament from expanding its powers. So you could then talk about double majority here and say, well, if the Commonwealth Parliament wants to make laws on religion, such as they want to establish a religion, first they would have to change the Constitution. And the Commonwealth Parliament cannot change the Constitution without the approval of the Australian people. Therefore, they would not be able to establish any laws on religion. They would not be able to make certain laws on religion without asking the Australian people for approval first. And then you could talk about, I suppose, the likelihood of that actually occurring, and then more or less come to a pretty definitive view of, hey, the Australian people can prevent the Commonwealth Parliament to a great extent on making laws on religion that, in relation to Section 116, because one, they're probably going to vote no to a constitutional change. Two, they can bring a High Court challenge if the Commonwealth makes a law that breaches this right anyway without having a referendum first, and therefore the Australian people have a pretty great say in and can check the Commonwealth Parliament quite heavily on making any laws on religion. So as I said, the real key skill here, obviously analyse the ability of the Australian people as well, as we've seen with those questions. And look, I recommend going to those examination reports, reading those fully, and maybe even having a crack at these questions yourself based on the info that's been given here. But just to finish off and bring all of the information together, if we are evaluating the ways in which the Australian Constitution acts as a check on Parliament and lawmaking, we can construct a table something like this. So ways that the Constitution does check Parliament. High Court can declare laws invalid. High Court can find new implied rights. There's a separation of powers that can't be legislated away. Parliament can't breach express rights. And bicameral structure means any new laws must be debated. But we could also go the other way and say, well, it's not a check, and some of the things that came up in the examination report there are that. So express rights are limited in scope particularly, and that's that section 116 question. High Court only works if people bring a case. So that's the ability of the Australian people question from 2018. Only one implied right has been found. And really that I suppose that 2018 question on the lowering the voting age law that the Greens wanted to pass, understanding that if you read that case study and the government had a majority in both houses, therefore they would just be able to pass whatever they want. So that's potentially an outcome down the track, is that you have a Senate that's a rubber stamp. So again, just the idea of making sure we know both how it is a check, but also some of those things that the examiners have brought up that show that it isn't a check at all on Parliament's lawmaking. Look, quite a long one, but hopefully you've been able to pull a little bit of extra information out of this and see how those checks work in practice. But particularly, hopefully you have first and foremost been able to understand how the examiners want to assess you on this. So what questions are they going to ask you? And as you'd see, they're not going to just ask that really basic evaluate question. They're putting in little things like the Australian people, the little prompt on the section 116, because they want you to be able to adapt your understanding to specific prompts without just writing rote learned responses. So really making sure that you get a good depth understanding to be able to respond to those prompts as they come up. As always, any feedback, feel free to send through. Hopefully this proves pretty helpful as you move forward, because, you should probably expect to get a question like this on the exam at the end of the year. Good luck for any upcoming SACs you have, and we'll see if we can't get a video out for 4.2 as well.